In the previous videos, we have discussed the relationship between protest, democracy, human rights, and the Constitution. While we have seen how the right to protest is protected at many levels, the state nevertheless retains several tools to regulate and restrict protest. At the moment, how can the British state regulate protests? For example, by preventing them from taking place or placing limitations on their conduct. There are many different pieces of legislation that regulate protest, and I'm not going to discuss all of them. The Public Order Act 1986 is the main instrument which regulates processions, i.e. marches, and assemblies, which are static protests. Among other things, it establishes some procedural limitations. Section 11 requires that at least 6 days' notice is given in advance of a procession that does not customarily take place. Section 12 allows the police to issue limits on public processions, normally relating to the route, the duration, or the numbers of participants. These limits can be placed if A. they may result in serious public disorder, damage to property, or disruption to the life of the community, or B. if the purpose of the march is to intimidate. Section 13 allows the police to ban a protest for up to 3 months if they reasonably believe that Section 12 does not give them sufficient power to prevent serious public disorder. This requires ministerial approval. The Public Order Act also regulates the procedure around assemblies. Section 14 is similar to Sections 12 and 13, enabling the police to impose conditions on the assembly. Section 14A, first added in 1994, lets the police ban the assembly entirely if it has 20 or more participants, it's taking place on private land or land with limited rights of public access, where the occupier has not granted permission, and if it may result in serious disruption of the life of the community or to land, buildings, or monuments. For each of these provisions, there are associated criminal offences relating to organising something that is held illegally and knowingly participating in a banned procession or assembly. Another notable criminal offence under the Public Order Act is in Sections 4 to 5, which limit what can be said or displayed on placards during a procession or an assembly. Section 4 makes it an offence to use or display any intentionally abusive, threatening or insulting words or behaviour where you also intend this to cause or provoke unlawful violence, or cause another to believe that they are at risk of unlawful violence. Sections 4A and 5 are similar, but they focus on using abusive, threatening or insulting words or behaviour to cause distress or harassment, not violence. Section 4A prohibits the intentional cause of distress or harassment, and Section 5 kicks in if your actions are within the hearing or sight of someone likely to be caused harassment, distress or alarm, but no one actually needs to be alarmed for that. There are defences available here, of course, for example, if the statements are truthful, but that's not really my focus. The point is that there are clear limits on what can be said and done during protests. As well as that, the ordinary criminal law may well be engaged during a march or an assembly. For example, graffiti can amount to criminal damage, contrary to the Criminal Damage Act of 1972, and the offence of riot is under the Public Order Act.